Welcome to part 3 of AASB's Virtual Summer Law Clinic webinar series. I am Shalicia Robinson, AASB's Assistant Director of Public Relations and the host of this session. Before we begin with our housekeeping items, I would like to take an opportunity to highlight one of our Platinum Sustaining members. Please take a moment to watch this brief message from McKee and Associates.
McKee & Associates not only works with school systems to build quality buildings and exceptional learning facilities, but also works closely with local boards of education and career tech programs. McKee takes pride in helping young men and women grow into the fields of architecture, interior design, and construction. In this case, Elmore County's pre-engineering drafting and design program.
Having an industry partner like McKee & Associates, very beneficial because the kids, we do projects all the time in the classroom off of a lesson plan. When they can work with an architect and actually do some of the live work, it's different than what they're used to seeing.
Most recently, students were able to collaborate with McKee in the design and layout of the new facilities of the Elmore County Career Technical Center.
Some of the students in the classroom got together, we had a team, and they actually worked on some of the programming for the new school that's being built here on campus. And they spent a ton of time going to all the teachers, interviewing the teachers, measuring equipment, getting all the specifications, electrical requirements, the heating and air, all the nuts and bolts. And then they went through and they took the architect's plans, which were preliminary, and they went in and tried to fit all those components and inside the building. When they saw all the plans and everything that goes into that, it was exciting for them.
Giving students the real-world experience of helping design a building on their own campus cannot be emulated and is something we can look back on and be proud of.
Thank you, McKee & Associates, for your continued support of education in Alabama. Now I have a few housekeeping items. First of all, you may wish to disable your screensaver so your computer won't time out during the webinar. At this time, we have muted all lines. If time permits, at the end of this presentation, you can type in the chat box online to ask questions. This webinar will be recorded. Being that this is a 4-part webinar series, school board members will receive 1 hour of training credit for each webinar you complete. These hours help you fulfill state training requirements. However, to receive credit, you must email the sign-in sheet to the AASB office after this call. The deadline to submit all sign-in sheets is next Wednesday, June 24th. If you do not have a sign-in sheet, send an email to membership@alabamaschoolboards.org. All registrants have complimentary access to the webinar archives in the Law Clinic branch of School Board U. If you need help accessing the Law Clinic branch or School Board U, contact Whitney at sbu@alabamaschoolboards.org or call 334-277-9700. If you have any trouble during this call or while viewing the presentation, call customer service at 855-352-9002. Have the webinar ID handy, which was in the reminder email sent to you yesterday. At the end of this session, we will have an attendance prize, but you must remain on the webinar to win, so you'll want to stick around. Now on to the webinar. Join with us today, we have Yuengert and Knox Averitt, both partners with the Birmingham-based Bradley law firm. They will share key considerations for local boards of education regarding the Americans with Disabilities Act and the Family Medical Leave Act, with specific guidance on issues related to COVID-19. Now I will turn it over to Knox.
So to get started, I know this is you know, we present on the ADA and the FMLA all the time, and this is such an unusual year in so many ways, and that's true, I think, for what we're going to see with accommodating and thinking through both the Americans with Disabilities Act as well as the Family and Medical Leave Act. But just as a refresher, I thought we'd walk through what the ADA says. So the ADA basics are that you can't discriminate against any of your employees or your applicants based on disability. So you could be sued under the ADA by somebody that never worked for you, who you did not hire, if there's some concern, if they claim that you did not accommodate them through the hiring process. So we have people who might interview who need assistance with reading and writing or with accessing a form, who might have vision issues or might have issues with verbal articulation, who need accommodations just for the hiring and onboarding process. So that's something we want to be thinking through from the start. That could come up now in the COVID context. If we have somebody who's high risk who wants to interview for a job but doesn't want to come to our brick and mortar office and go through a normal interview process, that might be something we need to think through accommodating. That applies to your private employers as well as state and local governments, including schools. It has a 15 employee threshold. So if you have less than 15 employees, and I don't think anybody that we're talking with today does, but that's something to keep in mind. The prohibited actions under the ADA are that you may not discriminate based on disability. You can't make employment decisions based on somebody's disability, either hiring, promotion, discipline, training. You can't retaliate if they seek an accommodation or raise a complaint about disparate treatment for disability. The other areas outside of the employment decisions themselves are the interactive process. So you don't want to factor in that somebody has a disability, or we think they might, when you're making these decisions. But if they do need an accommodation, we do have to pay attention to that, and we do have to have those conversations, and we'll talk about what those look like a little further. The other thing to think about is there are prohibitions under the ADA about what you can ask as far as medical information. So typically you have your job applicant and you make your hiring decision for a position, and then after the offer is made, then you can ask some medical information to make sure that someone is capable of performing the duties of that job. So your questions have to be tailored to what are the responsibilities of that position, if they have lifting restrictions, standing requirements, things like that. And then if there is some concern about that person being able to perform those responsibilities, then you have the conversation about what can we do to help you perform those responsibilities, and are those things we can do to reasonably accommodate you without materially changing that position.
One of the things that I have been warning people about with regard to illegal medical inquiries, because this has gotten really confusing in COVID. Just as a general matter, you shouldn't be taking people's temperatures when they come to work. COVID has changed that idea, because taking their body temperature is in fact a medical inquiry, by the way. What has happened is, because of COVID and because of the pandemic, the EEOC has made clear that in this circumstance, you're allowed to make that medical inquiry. You can inquire about how they feel, how they're doing, are they sick, because you have we have a high level of need to know that. It's business related, so that we can keep everybody in our businesses safe. But I want to make clear to everybody that everybody's getting kind of used to having their temperature taken, or saying we're going to take temperatures, or requiring people to be tested for COVID. Those may or may not be okay, except in a pandemic. So I found out from one client that their HR person would go and take people's temperatures before, if they just thought they were maybe sick, which is probably not a great idea. The other thing to keep in mind, if you're going to take temperatures, if you're going to do things like that, you have to keep that information confidential. You cannot share it with everybody else in the workforce. You can't even tell somebody that, oh my gosh, Ann's got COVID. Isn't that awful? That's a medical information that you are not allowed to share with the coworkers. We'll talk about, you are allowed to tell them that they might have been exposed to somebody with COVID, but you cannot tell everybody that I've got COVID. You're not allowed to do that. And I've had a situation come up specifically that, one of the supervisors told everybody, oh my gosh, so-and-so is sick. That's awful, right? Well, we got a complaint that we were sharing confidential medical information. And in fact, it was confidential medical information. So I just throw that in there to make clear that we are in a different place with ADA on this issue than we might be in 6 months.
So defining a disability under the ADA, this is a broad category that can constitute a physical or mental impairment substantially limiting one or more major life activities, having a record of such impairment. So maybe someone has, doesn't have the same restrictions they've had in the past, but, it's on our radar, it's somehow brought to our attention that they have in the past, or they're being regarded as having such an impairment.
And if you think this is broad, it's supposed to be broad. The law is supposed to be broadly defining a disability. The other thing about being regarded as, I think in this situation with COVID, this is going to be a big part of this. So you've got somebody who comes to work who they have an underlying medical condition that may be a disability under the ADA, but it may not be. If we treat them like they're disabled and tell them they can't come to work because we don't want them to get sick, that's regarding them as having an impairment, even if they might not legally have one. So we need to be careful about making decisions, employment decisions, they might be for that employee's best interest, but we're not allowed to make that decision. The employee has to.
That's right. And the other category we're seeing that we need to be careful about, and we're not speaking on it today, but we're seeing this kind of overlap with claims of age discrimination. I know there's a lot of concern about, older folks being at higher risk if they contract COVID, but again, we have to be respectful and let employees make their own decisions. If they are, of advanced age, that's still their decision on how to move forward with their employment. If you have teachers who are a little older and are coming back in the fall, that's still their decision. We can't take them out of the classroom because we're concerned about them being higher risk. So if you do have somebody who comes to you, thinks they have some restrictions, might be disabled, and you're starting the discussion about a reasonable accommodation, you're starting that interactive process, the thing to keep in mind is to be a qualified individual for an accommodation under the ADA, the person must be qualified. That means that with a reasonable accommodation or without, they are able to perform the essential functions of the job. So if you have somebody who wants an accommodation, but they want it to be that somebody else is hired to work alongside them, that's probably not reasonable. This is kind of a multi-factor test as to what amounts to a qualified individual. It's a sliding scale. It's a little squishy, and especially in times of COVID, it's going to look a little different. But a good thing to go back to is the pre-existing job description. That may be harder to do in a time like this when we're seeing a lot of activities occur virtually, but that's at least a good start. The other thing is the accommodation cannot require any direct threat of harm. So for example, if you have someone with a mental impairment, if you have, if they've got some kind of condition that's impairing their judgment or impairing their ability to make decisions for our students, and that's compromising student safety, that would be considered a direct threat. A reasonable accommodation can be anything that enables an employee to perform a job's essential functions. So what we might see at a time like this, or at any time really, is a reassignment to a vacancy, a modified facility or schedule if they have difficulty being on their feet for a certain amount of time. There may be a restriction on the schedule they can work. We might see a modified schedule. The EEOC is very interested in leave from a job as a reasonable accommodation. So if someone exhausts their FMLA leave, we've got to look at additional leave as a potential reasonable accommodation. And it's still very up in the air as to how long is reasonable.
The other thing to keep in mind on the reasonable accommodation discussion, so when we say modified facility or schedule, this is coming up a lot with people who are afraid of getting COVID, who are in a higher risk category, might have an underlying medical condition. So how can you modify the facility to ensure 6 feet of distance between everybody, to ensure that it's clean, that they are not going to be exposed, or certainly no more exposed than they will be anywhere else, like at the grocery store or places like that. But the accommodation discussion is really on us to be creative in a way to find a way to get the disabled employee to work. In this environment, there is no automatic, like if you get COVID and you are sick, then you're not going to come to work. That we don't want you at work because you could pose a direct threat. It's really going to be the people who have these underlying medical conditions, and we have told them for the last 3 months that they can work from home, even though they really can't. We have been pretending that everyone could work remotely in a lot of instances, and I know that the schools really have done this. Most jobs at the schools are not good remote jobs. We need people at the schools to do them. And so it's going to be a process to get people back to work. I talked with a school system the other day about an admin, one of the secretaries at one of the schools, and what we could do to prevent people getting within 6 feet of this secretary, to make her more comfortable with being at the school. And I think that there are a lot of options there. We just have to be open to them, and we need to run through that whole process before we give up on it. And sometimes we're not going to be able to reasonably accommodate somebody, but we don't want to get there too soon. And we never want to assume that we can't. So that goes to the last point, talk to the employee. You have to have a long conversation. So we're going to walk through all these steps. Back to you, Ann Knox.
So the first step in this discussion in the interactive process is the employee requests an accommodation. So the employee has to raise it to our attention that there may need to be some kind of accommodation or modification. Don't necessarily have to mention the ADA. They don't necessarily have to mention that they believe they are disabled. So they may have they may say, I'm high risk for COVID. I need help because I've got this issue. And then that goes to us. And, a lot of times Ann and I will have this come across our desk when the conversation has already ended and the employee has said something that may have been a little unclear, but then the folks on our end in HR have not followed up the way we wish they had. So if there's any kind of alarm bell that goes off that it could be an accommodation or that one might be needed, I like to see that the people on our end have responded. If it's a direct supervisor has raised this with HR, it's gone up the chain, then we've looked into it. We've asked them to send us information from their doctor to give us more information. Even just a request for a little more details then puts the ball back in their court to give us specifics as to what they need. And the thing about COVID is we are all bending over backwards to be creative and figure out our best way to keep everybody safe and get everybody back to school and to work. And, you know, how are we going to keep everybody distant and keep them safe and clean? And are we going to have masks and, you know, different routes in and out of the school? And are we going to have, you know, we're just looking at all of the things. So the more specifics we can get from an employee requesting an accommodation in these times will help us figure out what do they need that we're not going to already be modifying to provide for the rest of our students and faculty and staff. So, you know, if they do raise a concern with you, you can ask what the disability is, but don't get hung up right on the front end of whether you think it's a disability. Let us later down the line, if there's still some dispute, you know, split hairs over whether that constitutes a disability under the ADA. You know, you go ahead and just treat it like it is and start that conversation, and let's figure out if we can accommodate it. Or if you think that's something we can't accommodate, because maybe we can go back to them and say, okay, here's what we can do. Here's what these additional records from your doctor show that we've, you know, gotten down the line and we think we can work with. So don't just end the conversation because you think it either doesn't amount to something under the ADA or that we can't provide it. So again, talk to the employee about what they're looking for. Sometimes it's something that, you know, is just a preference. We've had folks who are raising claims for accommodation because they don't like the the schedule that they had to be on for a certain amount of time and there wasn't some medical condition tied to it. You know, there was some part of their job. I've had cafeteria workers who really liked working in the front of the lunchroom where they got to talk to people and didn't want to take out the trash in the back. I mean, that's not an ADA issue. That's your job preferences, and that's still part of your responsibilities. But getting there through the interactive process to drill down on what they're looking for and what the issue is about protects us.
The other thing to keep in mind on the heels of that is don't be afraid to ask, because as long as what you're asking is, so tell me what about your job you are having difficulty doing. Just tell me what that is and why you're having a difficulty. There's no bad answer for us on that. Nothing that they can say is going to make the situation worse. If we don't ask, then down the road when we get sued, then they're writing on a clean slate. Well, they never even asked me what I needed. They didn't talk to my doctor. They didn't do all that stuff. This interactive process is really, and it's not a one-time conversation. You don't have to give an answer in the first part of the conversation. You can ask, you can collect all the things that they or their doctor are asking. I like getting the doctor to weigh in. I've had doctors come in to a workplace to see what it was like so that we could explain to them what we were concerned about and why we couldn't do what the employee was asking. And then they say, well, you're right, they can't possibly do this. Right. And if their doctor says that, we're in good shape to say, well, we can't accommodate. But we never want to start with the assumption that we can't. And so don't be afraid to ask. Don't be afraid to get the wish list from the employee, because you can always say, well, let me look, let me see what we can do, and we'll be back with you. And then you sit down and we're going to come back. And the key for us is we want to look really reasonable about how we approach this, that our goal was to accommodate. And if we ultimately conclude that we can't, then we're in the best position that we can possibly be in, because we've tried everything to get this person back to work. So don't be afraid to ask. Don't be afraid to hear something from the employee's doctor. So
I would absolutely encourage you every time to, number one, get their wish list, and number two, get the doctor's note, because a lot of time their wish list will far exceed what's in the doctor's note, or they won't follow up at all, and so you won't get a doctor's note. And so then down the line, if if they bring a claim, the ball looks like it was still in their court because they didn't come. We said we want to see what your doctor says so we can figure this out, and then they never brought that. So that makes us look very reasonable, like we made the efforts and then they didn't follow up. So that really changes course even if otherwise, you know, the facts didn't change. So those are two very easy things to do on the front end that will give us a lot of information and put us in a much better situation to defend any claim that comes down the road.
And all of this should be documented. I don't want you to tape your conversations or record your conversations with an employee, but I do want you to have a letter that outlines what they told you so that we are sure that we've got their wish list. Getting them to submit something in writing is fine. Sending them a follow-up email. Any of this is good, but you want to make sure that our discussion is somehow on paper. You don't have to have them sign it. Just an interactive back and forth. Could be an email, could be letters.
That's right. So assuming we get all that in place, which we recommend every time, then getting down the road, we'll look at if what they're requesting or even what the doctor says they can or can't do, is it reasonable? It is not reasonable if it eliminates an essential function of their job. So there are certain instances where an employee comes and says, I can only work 8 hours a day, 5 days a week. There's no way I can, you know, based on my back restrictions, my injury, there's no way I can ever work more than that. And if this is somebody I'm thinking of who was in a managerial position and we needed that person to be able to cover if the hourly employees were out, if there was some emergency at the retail location, you know, we needed there to be a flexibility there of being able to work longer than 8 hours a day, 5 days a week if we needed it. And you know, schools are the same way where sometimes you have things come up, you need flexibility. And the court sided with us that the time availability of that job was an essential function, and therefore accommodating that person to only be there 8 hours a day, you know, a certain number of days a week, eliminated an essential function, his availability, his flexibility, and therefore we didn't have to provide that. Another one, like we've talked about, is if something poses a direct threat of imminent harm. If, like I mentioned earlier, if there's some kind of mental impairment that somehow compromises student safety, that's, you know, that's an area we don't want to get into.
So, and I can give you a good example of a direct threat with a teacher. I had a situation where it was somebody who was the only adult in the room with children who had autism. And so these children you needed to keep an eye on them, and you needed to make sure that they were safe. This teacher had a seizure disorder. And sometimes when she would have a seizure, she would just zone out. And so we couldn't accommodate her in her job short of bringing in another teacher to be with her, because she couldn't tell us when she was likely to have a seizure. And when she had a seizure, there was nobody supervising these children. It was dangerous for her. It was dangerous for them. But one of the things we talked about was, do you get an aura? Do you have some indication so that you can call for help? How can we address that? And her doctor ultimately said, no, that's not going to work. Well, we couldn't accommodate her in that job. So we had to look, could we move her to another position? But those are the kinds of things that pose direct threats. On the undue hardship, go ahead. And on the undue hardship, we never want to get to undue hardship. It's a really hard, you know, that's a legal argument that we'll make down the road. We don't want to say, well, this just costs too much, unless it's got to be ridiculously expensive before it costs too much. So, and the other thing is employees feeling like they're having to do something that because this other employee is being accommodated. That's not an undue hardship. That's just bad morale. That's just an HR problem, but the ADA doesn't care about it.
That's exactly what I was going to say, is undue hardship is not a place you want to be arguing from. That's something we add in that, you know, if we have to take the case to trial, we're putting everything before the jury, then we're arguing undue hardship. But that's not a threshold category that gets the case thrown out. It's not a place you want to get. Are there other options? You know, if that position, if we can't accommodate someone in the position they're in because of the essential functions, we look at, so we have other available positions that we could put them, you know, can we transfer that employee into another position? Can we put them in another location? Is just kind of cast a wide net. It doesn't help just to be narrow and think, okay, that person can't do this job once they're, you know, once they're our employee. We have to look at what else we can do for them to keep them employed with something they can actually do. So a lot of times that looks like transferring to a different position, even if they take a pay cut, even if, you know, it's a totally different job, if they're qualified, you know, if they meet the qualifications for it and it's something their impairment doesn't keep them from doing, that's the next option to look at. So examples we're seeing of accommodations right now, who might be higher risk for COVID. Again, we want to think through what all are we doing to modify the environment for everybody, because this is, you know, we don't want anybody to come to school or to work and be at risk to contract COVID. We want to minimize that as much as possible. And so I know we're all looking at kind of remote work or rotating schedules or spreading out a little more, or taking different entrances and exits in the building. I know y'all are looking at everything and it's still up in the air. But beyond that, you know, we're seeing potential accommodations for employees who are higher risk. Can they be transferred to a work area that's a little more isolated? If we have an office employee who typically sits at the reception desk, can we put him or her, you know, in a back office where there's not as much exposure to people coming through the building? Is a modified work schedule a possibility? Is a remote work environment possible? And I know this is tough because we have had so much virtual learning in the last few months, and that's something that, you know, has worked well, or we've made it work in some cases, and is not ideal for a lot of our employees. You know, there is good case law that just because an accommodation has been granted in the past, that doesn't make it reasonable. So I expect we'll see a little bit more of that in the coming months as things unfold and we do try to get back in the building as much as possible. You know,
And
can we
so-
put up different barriers as an accommodation, just different ways that we can add, you know, minimize exposure for our high-risk employees.
And the example that we've got here about a claustrophobic employee who doesn't want to wear a mask. They say, if I wear a mask, I'm so claustrophobic that's a real problem for me. And I'm being treated for claustrophobia. I've got a doctor who'll say it. The conversation that we had with that employee was, does that mean that you can't wear a mask at all? Because if you are interacting with other people at this particular employer, so what if you only wear it when you were directly engaging with somebody? What if you could take it off otherwise? Are you so claustrophobic that there is no way that you can wear the mask? And get the employee and the doctor to weigh in on that so that we can see if we can accommodate it. And maybe we can and maybe we can't. But that's the way you have to approach it. You just have to be really flexible to see how to get the job done and how to make that work. And we know it's going to be almost impossible when you have teachers who don't want to be in a classroom setting and they've been teaching remotely. We're just going to have to see what the State Department guidance is going to provide us on this. And also, the other thing to keep in mind is that this is not a one and done. The CDC is putting out guidance all the time that changes with the situation, and we're just going to have to keep up with it. And what is reasonable today might not be reasonable in 2 weeks or in a month. So we're just going to have to keep an eye on it and not be afraid to reassess. So let's talk about FMLA.
So moving on to FMLA. So we've got this extra temporary extended FMLA for childcare purposes that we'll talk about, but just back to the basic FMLA before, the last few months, eligible employees may have 12 weeks of leave. They are entitled to continued benefits like health insurance during that time. That leave may be continuous or intermittent, meaning they take, chunks of time at once and come back to work. They take a few hours, they take a day or two and come back. It's only available for certain reasons, such as serious medical conditions or the birth of a child. Their job is protected when they are taking that leave. The law provides that only eligible employees are entitled to FMLA, but they're absolutely entitled to the 12 weeks of leave, so long as they are approved for a qualifying reason and they've been employed by us for working 1,250 hours over the last 12 months. You can't consider an employee's leave when you're making any kind of employment decision. So there's an anti-retaliation provision.
And make sure that whoever's administering your FMLA policies really looks at eligibility every time. I've had a lot of situations where clients call, they've had somebody, they've been on FMLA forever. Well, we found out ultimately that they probably weren't eligible. They hadn't worked for us for 12 months. They hadn't worked enough time in the last 12 months, or they had used, they're beyond their 12 weeks of leave. So it's really important to keep track of that. And not because I want to be mean and not give people leave, but because we need just to make sure that we're on top of it, because people get tired of people being on FMLA. I know it's a burden. Let's make sure that we're only giving them what they're entitled to.
That's right. And it's hard to navigate when you have a summer break and you have a spring break and a winter break and they've got all this other time that they may not be, thinking about it from the FMLA perspective, the way someone who works, 50 weeks a year continuously might. So there are some fine print about what employers are covered by the FMLA. Schools are covered employers regardless of how many employees they have. There's a special rule that's applicable to public school boards, elementary and secondary schools that are under the boards, private elementary and secondary schools. Doesn't apply to vocational schools, preschools, daycares. But for our purposes, we're covered employers. So, aside from the emergency FMLA that's come into play this year that we'll talk about, someone with COVID-19 or with a family member who has it may qualify as a serious health condition under the regular old school FMLA if that person is actually sick. Being a high-risk individual who's been recommended to quarantine probably doesn't amount to a serious health condition. I think that then goes back under the ADA. So you may look at some kind of accommodation of leave for that.
But that also depends on exactly what their underlying condition is.
Correct.
If they're just in a high risk because they're over 65, that's not a serious health condition.
Absolutely.
Soon to find out in the next several years. But the other thing is if they have an underlying health condition that is a serious health condition and their doctor has recommended that they quarantine or that they might be eligible for FMLA leave, and we might want to give it to them. So don't have a knee-jerk reaction about what is or isn't a serious health condition. Let's make sure that we're looking at that closely.
So emergency paid sick leave. This is the 10 days of paid sick leave that does not really kick in under the FMLA that was passed earlier this year that's COVID related. So you get 10 days of paid sick leave if you or someone you're caring for is isolating either based on a government stay-at-home order or a doctor's recommendation. You know, we've seen the stay-at-home orders relax in the last few weeks. There still may be doctor recommended isolations that come into play here. This covers the first 2 weeks of kind of the extended leave that was in the legislation that was passed. If somebody's experiencing symptoms of COVID-19, either the employee or someone for whom that person is caring, then that can trigger the emergency paid sick leave. The other reason that could trigger it is a lack of childcare. You know, that person's son or daughter's school or daycare is closed due to COVID-19.
So the other thing to keep in mind about the emergency paid sick leave, it's 80 hours, which, you know, is 10 days, 2 weeks. But if you have an employee who's only working part-time, they don't work 80 hours in a 2-week period, then they don't get 80 hours. They get it prorated. The other thing is let's say they thought they might be sick. They went to get tested. They are quarantined until they find out that they have a negative test. They could be using this emergency paid sick leave. So they're out, say, 3 days for that. They've used 3 days of the 10. They don't get a new 2-week bucket. So just keep that in mind, that this is once they use it, it's gone. And you can pay attention. Now, in schools, everybody's got a lot of other paid sick leave. You have to give this to them first. They're entitled to this under the law. So you have to track it that way. Now let's talk about the emergency paid sick leave for FMLA for childcare.
So the emergency paid FMLA for childcare can be available, which includes 2 weeks of the paid sick leave that we just talked about, to care for your son or daughter if the daycare or school is unavailable due to COVID-19. So if somebody who back in April or May, you know, their child's school was closed, their public school was closed due to COVID, and that child's at home doing distance learning, that was a qualifying reason then. Now that school is out for the summer, that likely is no longer a qualifying reason. So it just depends. It's getting a little squishier. I think we've heard some noise from the Department of Labor that this, you know, the qualifying reasons might shift a little bit now that there is more childcare available across the country, that, you know, daycares and camps and different options are opening up. So far the guidance on that has not changed, but we expect it could in the coming weeks. To be eligible for this, your employees must have been employed for at least 30 days. Like the emergency paid sick leave, the pay rate is 2/3 the regular rate or minimum wage, whichever is higher. You are entitled to a maximum of $200 a day or a total of $10,000 in addition to what you're entitled to under the 10 days of paid sick leave. Now, I know if you've been following this legislation in the media, you've heard about some tax credits that are available. Those are not available to governmental entities. So unfortunately, unfortunately, school boards are on the hook to provide this leave, but do not get the tax credit for it. So that's unfortunate there, but just so you're aware.
But the other thing to really keep in mind about this is that under the emergency paid FMLA, they still only get 12 weeks of leave. So if you've had someone who was out on maternity leave in January and they've used 4 weeks of leave and now they need this, they want paid FMLA because their child's daycare is closed for the summer, they've already used 4 of their 12 weeks. They don't get a new 12 weeks. And the first 4 weeks were unpaid FMLA unless they had PTO or paid benefits available. So this isn't a whole new number of 12 weeks. And the child care and the emergency paid sick leave will expire at the end of this year. unless it's extended.
That's right. So thinking through how the ADA and the FMLA interact, the FMLA is strictly about protected leave that the employee is entitled to. The business needs don't come into play. ADA is about making sure people are treated fairly, that there's not disparate treatment based on disability or the perception of a disability. The business needs do come into play. I think where we do see them overlap the most is if someone needs leave as the accommodation. And I think that we will see that more and more, with the COVID crisis continuing and there being a need to revisit what's reasonable as far as people working remotely, people's kind of high risk concerns about coming into the work environment and whether that's based on an actual underlying condition or if people are just afraid, because there is a lot of panic over the uncertainties of these times.
The other thing to keep in mind about leave as a reasonable accommodation, what I'm telling people is you walk through the accommodation process, you can't accommodate them currently. Now, if the reason that they want an accommodation or that they don't want to come to work is because of COVID. Now, hopefully at some point this crisis will end. We don't know when that'll be. We don't know if it'll be in 2 weeks when we get the miracle vaccine or if it'll be years. We just don't know. So I think that giving somebody options to take leave so that they can get more accustomed to the idea that we are going to be living with this for a long time, and they can't simply quarantine for the rest of their lives, and they can't do it for the next year. If we give them time and if we give them unpaid leave to do that, or they're allowed to take their regular leave. Now, I know for school systems, one of the big problems that you run into is if people aren't working, we need them on a leave so that they can remain eligible for their health insurance. Trying to find that balance is tough, but giving them leave to give them an opportunity to get back to work, to figure out really where is their fear level, because up to now, everybody was supposed to stay at home. There was no, well, maybe I should, get over this or be a little exposed. Everybody's been told to stay home. That's shifting, that's changing. Hopefully it'll get better. But giving people leave to get them where we need to be about coming to work is not a bad idea. I'm not saying that it should cost us a ton of money, but at the same time, kind of a slow walk getting them back, letting them know that we're trying to adjust the environment so that they can get back to work, that we want them back to work, that this is, and all of the things we're doing to help with that. But it's going to be a long process. It's not going to be something that happens overnight. But I've sat through conversations with employees where at the beginning of it, it was like, no, I just can't come back to work. And at the end of it, we had made some progress. It might not be perfect yet, but hopefully it'll get perfect as we move forward. We'll see what happens, but it's going to be complicated. So I think we're at the end of our presentation. So if anybody has questions or specific issues that you're concerned about, we've tried to bring up the ones that we are seeing currently. Like I said, I think when and if students come back to schools in the fall, it's going to become more complicated because, if we've got students in schools, we're going to have people in schools. And part of a teacher's job is to supervise a classroom. And that's going to be tough. I think everybody agrees from the remote learning experiment that we all just went through, that remote learning right now in our society is not ideal. And a lot of parents want their kids back at school. And so I think there's going to be a lot of push to get there. We're just going to have to see how it goes. So if there are any questions, we are happy to take some.
Yes, I see a few questions. I'll jump into the first one. It says a librarian writes a letter and states that she will not come back to work this year. She says she is going to work from home because she and her elderly mother are at risk. Is this a reasonable request? What is the next step for the school system?
I'll take the first shot at that. So the librarian, one, I would look at the librarian's job description, and which I assume has something to do with managing the library, which includes students coming into the library, which includes a lot of things that she probably needs to be available for. I think that your conversation is exactly what are the concerns? Can we address them with PPE, a mask, cleaning a library, limiting the number of students who come in at any given time, making sure that her interaction with students, she shouldn't have to get within 6 feet of them. But I would bet that you can push to say she's going to have to come into the library, that our librarian can't manage our library from home, but we're going to have to really look at it to make sure that we explain why and all of the different things that we've offered the librarian to get her back into the office. And it's a long process, and her concerns about her exposure and her exposing her mother are not unfounded. But I think that we have to have that conversation with her, because I don't think it is unlikely, I think, that at the end of that conversation we're going to say, yes, it's reasonable for you to work from home. I doubt that that's going to be where you land in that conversation, but it's going to have to be a process, and depends on what she says and what we do and all of those things.
Thank
Others?
you. Yes. The next question says, to make a decision on your virtual teachers, can you silently consider employee health issues?
So not talk about an employee's health, but just if we're going to have 5 virtual teachers, they just all happen to be employees that we're worried about their health. I assume that that's what that means. So we're considering their disability in dealing with that. I think a lot of people will do that in considering virtual teaching. So one of the things that I think is hard for people when they talk about remote work is they say, well, we don't ever have remote work. Well, now we've all had remote work, so we can't say we've never had it. You can still say we are only going to approve remote work in the case of a reasonable accommodation for a disability. So if someone is in fact disabled, so you have somebody who's got an underlying health condition who says, I want to work remotely because of that, you would go through all the ways that we want to try to get them back to work. And then if none of those, we can't find a good thing, we can consider remote work. But in this instance, we're allowed to consider whether remote work actually works for us. For example, in the situation with the librarian, if we come to the conclusion that a librarian doesn't do what we need her to do, she can't do her essential functions remotely. You might come to the same conclusion with some teachers, but maybe not all of them. I mean, maybe some teachers are effective remotely. It's some different classrooms, different issues. So you can make those decisions based on someone's disability in that situation. I would not put all of my, medically fragile people, I wouldn't just silently exclude them or put them in remote classrooms, in part because I think that remote situations, if down the road we decide that it's not working, those jobs are all at risk, and we have shunted all of our disabled people into them. So now we're just going to get rid of, we're going to do whatever, we're going to get rid of those jobs, and now it's because the reason they're in those jobs is because they're disabled. And so you have to be careful about making those decisions now, because the impact that you could have down the road could be a problem.
And it also seems up in the air that the virtual teachers will, I guess it'll depend on what school looks like in the fall. Do we have as much virtual class as we have in-person class? Are those positions going to be paid like the in-person positions? Are these people with health concerns, requesting to teach virtually? I think all of that comes into play, and we need to be sensitive. Maybe if they think that, everything else being equal, they might like to be the virtual teachers, but if there's less work to be done and the pay is lower, maybe not. And so I think, we just need to look at how many virtual teachers we have, how much work they're doing, what the compensation is, what the opportunities are. If those positions get eliminated, what we're going to do with those teachers.
Anything else, Shalicia?
Yeah, I'll read the last question. It says, can an employee who took a week of emergency paid sick leave 1 week, for example, for childcare reasons, take a second week of emergency paid sick leave a few months later for another allowable reason?
They can, so long as the Paid Sick Leave Act is still in play, which it is at the moment until the end of the calendar year. So through the end of December 2020, they're entitled to 10 total working days. So if they've already taken half of that, they could take the remainder for a different reason. Keep in mind the extended leave is for childcare only. So that's not going to come into play if they have to quarantine for 10 days and then they want additional leave beyond that, that would not be available except for childcare reasons. But you can take your 10 total days for separate reasons at separate times.
And if somebody they get sick, they have COVID, they have to quarantine, they're out for the 2 weeks, they've taken that, and they're still sick. And they might still be sick from COVID. They then don't get to dip into the additional 10 weeks for paid leave. They might have FMLA rights.
They might have PTO, and they might also have FMLA rights. So they may still get some paid leave from other sources, but not under that emergency paid sick leave.
Correct. If you think this is complicated, it is. And we have to look at it every time brand new and start back with the basics, because it is really complicated. Anything else?
No, I think that was our last question. So thank you both so much for such a wonderful presentation. Now we will jump into our attendance prize. And our winner for our attendance prize is Tony Simmons from Marshall County. So congratulations, Tony. You are the winner of an AASB tumbler and notebook, so we hope you will enjoy that. And before we go, I want to thank Ann Yuengert and Knox Averitt again for being with us today. I also want to thank all of you for participating in this webinar. We hope you found it to be useful. Join us next Wednesday, June 24th, for the last segment of AASB's Virtual Summer Law Clinic webinar series. We hope you will join us. You have a good afternoon.